Welcome today, Michelle. This is Michelle Brown of Brown Law. She's the founder and owner of the law office, and they service the GTA and communities around the GTA. Now, from what I understand, Michelle, you do wills and estates, personal injury, and disability claims.
I do, and some general litigation claims as well, any disputes between individuals.
Perfect. And you have over 20 years of advocating for your clients and their families and the community at large.
That is correct. And it's nice to be here, Eileen. Thank you for having me.
Awesome. Yeah, just to reintroduce myself, I'm Eileen Evans. I service the Toronto, Greater Toronto area. And really, I'm really interested right now in the amount of people. What I understand is only 27% of people in Canada have any estate planning set up, which really makes them vulnerable. So I've asked Michelle here today to really just get into some questions and questions that I've heard often. So the first question, Michelle, is what are the legal consequences when people just die without a will? What happens to all their stuff, their bank accounts? What happens?
Okay. So what happens is that the law dictates what happens to your assets when you die, as opposed to if you had a will, you get to dictate and say what happens to it. There's a law, it's called the Succession Law Reform Act, and that says how your things gets divided up if you don't have a will. But even before getting to that, there is the executor appointment, and that's who's going to administer and take care of your assets when you die. With a will, you get the opportunity to say, this is the person that I want it to be. It's not necessarily the oldest child or necessarily the spouse. It's really somebody who you think that has the time, has the ability. And so it's a serious, thought. You want to put serious thought into it and having somebody do that. So when you don't appoint someone who you think is best fit for that, anyone can then go to the court and prove to the court why they should be it. And they may appoint somebody who you may not have thought or wanted in that position. With respect to any assets that you have, what happens there is that the law says who gets what. So for example, if you're legally married, not common law, and you have no children, your spouse gets everything. Automatically. If you do have children, then your spouse is going to get the first $350,000, and then the remainder will be distributed among the children that you have. And then it goes down in your lineage. If there's no children, then it may go to parents. If there's no parents, then it goes to siblings. So the law really dictates in your family line who will get what you have. And that may be problematic. For example, if whatever you had, you thought that your spouse was going to get, and it would take care of your spouse. But then no, what happens is they're going to get $350,000 and everything gets distributed to the children. Well, maybe if that happens, your spouse can't continue to stay in the home or can't maintain what they have. And that's really not what you wanted to have happen. When you create the will, you then say who gets what. And, a lot of people are common law. What I just indicated doesn't apply. They don't get the first $350,000. If they were dependent on their spouse, they can bring a dependency claim. That's other court procedures, more money again with that. With a will, you can appoint somebody to take care of your minor children. If you do have children. If you don't have will and that's not done, then the Office of the Children's Lawyer in Ontario, they manage the money for your kids until they turn 18. And even that in and of itself, children getting money at 18, if you're dealing with millions of dollars, is it okay for them to get it all at 18? Maybe you have a spendthrift child and that wouldn't make sense. Well, if you don't put that in a will and say no,
and that much money don't always work together, right?
Exactly. Yeah. With that will, you can say, okay, maybe they get an amount at 18, 21, and then really stage it how they get it over over time.
Awesome.
And, you know, not getting a plan done or not getting the will done, you're really not looking at how to, let's say, save on costs, save on taxes, things like that. So that in and of itself as well is, well, how much am I giving away per se, as opposed to my family or my beneficiaries getting as much as they can in the process.
So I have another question. Is so if a couple dies and they have, and let's say they have adult children, someone dies, they have adult children, no will, but the ownership of the property is in the husband's name. He died. There's no will. The spouse would have to sell the home. They would get the first 350, and they would have to sell the home in order to satisfy the rest of it. Is that correct?
Unless there's money somewhere else that can be tapped into to pay out what would be owed. But oftentimes, especially these days, people's assets are in their home.
Right.
So if there's not enough to pay out, then yes, the home may have to be sold. But even let's step back a little bit, Eileen, before the children or anyone gets anything, the debts have to be paid. So
okay, all right.
You know, the debts and taxes, remember, you often hear people say those are certainties. So if in this scenario, dad died and had debts, the debts have to be paid
before anybody else.
Anybody else gets.
Okay.
And that's assuming that you know, dad was sole owner and mom wasn't owner.
I'm the title. Right.
Yeah.
Okay. So what is probate? How does probate work?
So probate is a term, you know, the legal term is really getting administration, a certificate of administration for the estate to be able to distribute the estate. So there's getting a certificate with a will and getting a certificate without a will. The first thing that's looked at is it even required? It's not mandatory all the time. It all depends on how assets are held. So for example, if you have a husband and wife relationship where things are jointly owned across the board, bank accounts are joint, home is joint, they hold everything together. When one spouse dies, it automatically goes to the other spouse. So there may not be a need to get a certificate or to have probate done. Where there are assets that have to be transferred, probate may be needed. You know, just because your spouse or your wife and you go to the bank and say, yeah, my wife died, I just want to take the money out of the bank. No, it doesn't work like that, because they have a legal obligation, a fiduciary obligation also to the potential beneficiaries. They have an obligation to the estate. So they're not just going to turn over the money, because maybe, as I just indicated before, that it's not just spouse, there are children. And if there's no will, then the distribution has to be correct. So the bank could then be on the hook if they've transferred money and it didn't really belong to the spouse. So there are certain situations where maybe it's not needed, but if it is needed, then an application is done. If there's a will, you need the original will. There's an application that's completed and it's filed in the Superior Court, depending on what jurisdiction you're in. It could be 6 to 8 weeks. In Toronto, not so much. It could take months for that certificate to come back. And once you have that certificate, it's called a certificate of appointment of an estate trustee, with or without a will. And then that allows for the administering of the estate, of the assets. And, you know, tax returns have to be filed. As I said before, debts have to be paid. Once all the debts are paid, taxes are done, this is now at the point where the assets can be distributed. So the beneficiaries get what their allotment was indicated in the will. And if not in the will, however, the Succession Law Reform Act determines how it should be distributed.
Yeah. So I guess this leads into my other question. Those are the potential costs and delays associated with probate. So you've said in Ontario it could take longer than 6 weeks. You said you didn't
in Toronto.
in Toronto. So what are the potential costs then associated with it? Is there any cost you can put on that? Yeah.
So in order to obtain the certificate, probate fees or taxes, estate taxes have to be paid to the court. In Ontario, it's 1.5% of the value of the estate over 50,000. So the first 50,000, there's no taxes payable. After that, so for example, if the estate is $100,000, a fee of $750 has to be paid to the court when the application is made. If it's $1 million, you're looking at over $14,000 or about $14,200 in taxes that have to be paid for the filing. So there's that initial cost. That cost is the estate cost, not the executor who will be filing for the application. If those funds are used from the executor, then they do have the right to get those funds back because it is an estate cost. If the individual is not doing it themselves, it's not always an easy process. It all depends on the situation. If not, then there's, of course, the legal fees that are involved, and it could be an hourly wage. There's no set legal fee in terms of what that amount is. It's each individual lawyer will have their fees in terms of what that is. If there is, no will, then those costs are more because then there's other things that have to be obtained. For example, a motion and order has to be obtained for a bond. If whoever is applying is not in Ontario, then they may have to get a bond, or they'll have to get a motion, an order from the court that will dispense with that to say that they can be executor, because your executor should be resident in Ontario in order to file for the application. So it really can change. And that's why when you don't have it, it really does increase the costs and the time, because more things have to be done. Usually when the will is done, when you sit down with the lawyer, you talk about everything that you have and you're listing everything. When that person passes, that's an excellent starting point to say, okay, mom or dad had this, because they've said it all out. Right.
Makes it a lot easier if you set it all out.
Yeah. Exactly. And then I'm sure you've heard of they've got to go through drawers and shoe boxes and all these things to find things. But when it's done up front, the lawyer should be getting you organized, and you're really looking at, okay, what do I have at this point and what do I want to do with it? And also, when you pass, your loved ones know that these are the things that you had, and these are the things that should be looked for. Then it's not that extra added time just searching everywhere and trying to find things.
You know what, Michelle, I'm actually coming up with a life in order checklist, and it's something that checklist that I found, but I'm realizing I'm saying, okay, if you're aging parents, this is what you need, but I'm looking at it, I'm like, this is what I need now, because if God forbid anything happened to me or my spouse, my sons have to look for this stuff, because it's not all in one place. And, even though I have my estate set up, but all these little documents that are required are all in different places. So,
there's even, I had a private investigator call me the other day. It wasn't with a client of mine, but the private investigator called looking for someone who had a pension and should have cashed the pension, but didn't cash the pension. And was looking for the children of the deceased. So had, the plan been done, knowing about the pension, because these are maybe things that was put into place years ago. They don't even work there anymore.
Of course.
And so that will really help the process in terms of, having that checklist, as you said, that life checklist.
Yeah.
Knowing what's there and who to contact.
Yeah, that's quite common. You start working a place, years go by, and if something happens to you, your kids are not going to remember that there's supposed to be something there, right? So, okay. So we've talked about minimizing taxes. How can we, I have a question, how can we ensure that our wishes and our children's inheritance, the wishes we have, are carried out? Is that just simply by just having the will in place?
Right. That's just making sure that you have a valid will.
Yeah.
I definitely, for obvious reasons, do not recommend, downloading something offline, and people often do that.
Yeah.
But then what they don't realize is it wasn't witnessed, or it wasn't witnessed correctly, and so it's not something that's valid. Motions, and you can go to court to prove things. Again, going to court always costs
That's
extra
money.
money.
Yeah.
And in making the will, it's important that you're choosing an executor that you trust. Okay. I said before, it's not who thinks that they should be it.
Right.
It's who you believe that, would have, similar values to you. You can trust that what you say that you want done, they're going to do that. You want to consider, if you have minor children, having the guardian for the children, or who's going to hold that money for your child before they turn 18, rather than having the children's lawyer. Those are things that you're going to think about. Who's responsible? Who has similar values or upbringing that you would want your child to have, right? Yeah. Looking at the assets that you have, financial accounts, whether it's TFSAs, RSPs, that really goes into what you're going to do. How can I then reduce my taxes? Sometimes people may have a TFSA and they don't have a beneficiary on it. That's just going to fall into the estate. Well, maybe they do want to fall into the estate. Not everyone, will have a similar way that they want things distributed. But then you really want to talk with someone and say, okay, how can I minimize that? If I have an insurance policy, for example, or my RSPs or my TFSAs, if you can have a beneficiary designation on it, that goes automatically to your designated beneficiary. Then what happens? You're going to reduce then the probate fees, the taxes that you have to pay to the court on that, because it doesn't fall into the estate. It just gets distributed outside of that. So, whether or not you're going to add somebody to your account, will you own an account jointly? Or are you going to leave it separately? Remember before I said, if the account is joint, what's in it will automatically go over. There's no probate fees that are going to be attached to that. And again, it's not always that's the goal. But at least it's a consideration in terms of, if you know that you want to, the question you're asking about making sure the children get what you want them to get, I'm sure it's that maximum amount potentially, right? So it's crafting it and thinking about the different ways that you can optimize that.
Right. So how can as people age and maybe adult children, there's stepchildren involved in a different country that they haven't seen for their whole lives. Maybe they don't even know those stepchildren very well. So who can contest the will? Who can contest the will?
That's a good question. Really, anyone who feels that they have an entitlement can contest a will. Whether or not they'll be successful is another issue. But there is a legal obligation to provide for individuals that were dependent, whether or not they're minor or they're adult children. But if they can prove a dependency, or whether it was, a spouse, whether it was a stepchild, if they can prove that at the time of your death, they were dependent on you and you didn't leave them anything in there, yes, they can challenge the will for their fair share. If, in terms of having a will, if it was done, let's say, a long time ago, the situation changed and it wasn't taken into consideration. But of course, that's using evidence and having to prove that. Where there is no will, then of course it can be challenged. A child who there has been no relationship with the parent, just for that fact alone, would be entitled to, obtain from the assets of from the estate. It's important that individuals really, think about what they want to do with a blended family, especially where there's, new spouse, there's different children, or even situations where, in the Caribbean community, sometimes we are that village and we take the village and grow. So you may have your niece or nephew. Are you in a position where you were then a parent? And were they dependent on you? Those are different challenges that can be made. But, saying that, when you do create your will, if there is someone that you do not want to give something to, the law does not require you to, unless that dependency that I talked about exists.
So if they're not dependent, let's say, all the kids are in their 40s or something, but there's one child that was, in the West Indies, you had them in the West Indies, and for whatever reason, you never paid much attention to them, let's say. And they're not dependent on you, but they feel like they're entitled to something. So they could legitimately contest the will.
They can try. Anybody could try. I don't think that they'll necessarily be successful.
Yeah.
But in that situation, if that's what my client wants to do, oftentimes you could even write in the will, you've considered that person, but it's my desire not to provide them with something. Or there's a separate letter written outside of the will why they were left out. But where you don't have a will, once there is that relationship, they're definitely entitled to something. And they do have to be notified about the death, about the estate, and what their entitlement would be.
Yeah, and obviously not having that will, and if that person, you go through what the Ontario laws say, but if that person decides that they want to be part of it, it can hold up everything. Right?
That's right. Well, that's correct. And so when we talked about even delay, that's a potential delay, because while somebody may know the person exists, they may not know where they are, but you still have to make efforts to find that person, right. Whether it's putting an ad out in a newspaper or something. So you do have to make efforts to find the individual.
Okay.
You can't just say, oh, they're not here, they'll never find out about them. No.
Yeah, that's not good. Everybody should be aware.
Yes.
So let's move on to power of attorney. So someone's incapacitated for whatever reason, and now they need someone to take care of their, their healthcare decisions or their, or their finances. If someone does not have a power of attorney, and they have, a whole bunch of bills to be paid and all the things that goes with life, what happens?
So there's two types of power of attorneys. First of all, there's one for healthcare and there's one for financial. In terms of decisions for healthcare, if there's no power of attorney for care in place, then the substitute decision maker can make those decisions, such as a spouse and adult child for the individual. Where you're dealing with financial decisions, again, remember before I said you can't go to the bank and say, I'm spouse, I need money, my spouse can't get to the money. They're not going to provide you with that money. There are limited situations where they will, if there's a specific need and they can see a receipt, let's say a hospital stay where it shows that their care is needed, they may write a check over to that hospital for the individual. Outside of those type of special situations, somebody's going to have to go to the court to get an order to be appointed as the guardian of that person's property. They just can't, go and demand to get the funds to deal with that. And so a lot of people think that what I need is only in the event that I'm gone, but very much so when I'm here as well. And it's important that, oftentimes dementia may set in or Alzheimer's may set in. It doesn't necessarily mean that they don't have capacity, but it's oftentimes when it's getting to that point where capacity is questionable that people are now looking to get it done. At that time, it's likely too late, because you have to have an understanding and appreciate what you have and the capacity to know how you want to distribute it or how it should be dealt with in order to grant a power of attorney.
Wow. So how do you as a lawyer, if an adult child comes in and you can see that they're trying to get the will done, from their parents, and you can see that the parent doesn't have the capacity anymore to make decisions, how do you deal with that?
Well, I cannot. I cannot prepare those documents. And even if an adult child brings a parent in to get these documents done, I don't have the adult child there. And in particular, where there are, other siblings, one of the things that has to be looked at is, are they making an independent decision, free of being coerced or free of being pressured by someone? So I would not have that child with the parent. I'm speaking to them so that I can, assess what their capacity is, make sure that they're doing this of free will and that it's outside of the child being there. And, the child may say, but mom asked me to bring them here. And it's not only for mom's interest, but it's for your interest as well. I say, you do not want to be in here. Trust me. When mom passes, you want to make sure that you can say, I wasn't there. I had nothing to do with it, because if there's something that's contested, then, your hands are kind of clean to say that you didn't pressure mom into doing this, and your siblings aren't offended by what's happened. And really, sometimes it's when it appears that the distribution is not fair or appears just, my antennas may go off to say, but if it's like something that's equal, that may be different. So
yeah. So are you stating then that once they've the dementia or some cognitive decline is set in, it's already too late to make a will?
Not blanketly. Sometimes it's really at the time that they've given the instruction to make the will. When they're signing, they also have that capacity and understanding of what they're signing. It may be that a capacity assessment has to be done to determine. That's extra cost as well. If the person has had, a family physician for a long period of time, and the family physician is able to write me a letter stating that they believe that the person is able to take care of and deal with all these things, that they have capacity. A lot of family doctors don't necessarily want to do that either for liability reasons. But yeah, there may be extra steps in that situation where you would have to make that assessment, and it may very well be they're not able to at that time do a power of attorney. So in that situation, they'd have to apply for guardianship if and when that's needed.
Okay, all right. So just a couple questions. We're both West Indian. What would you say? This is a Canadian problem. However, I know we probably have special issues in the West Indian community. So what can I ask you, what would you say is a common problem that you see with estate planning in the West Indian community?
I think that, one of the issues really is the cultural norms and avoidance of having death discussions. In itself. And even to carve out a little bit more when you talk about the West Indian community, then you're also talking about more of the males in the community that are really reluctant to get it done. There's just different, oftentimes, the family dynamics. You've talked about, the estranged children and the the different familial relationships that exist, and just to a lack of awareness. Many people don't know about any of these things that I've talked about because they don't want to have that discussion. They may see it as morbid, and it's just not something that's really spoken about in the home. And oftentimes, anything to do sometimes with systems, our community has a distrust of that, right? So I think those are the various things that you see. So I may see, oftentimes the females that are coming in, they're talking to their spouse or their husbands about it, but they don't want to do it. So that's common as well. But I do think that slowly I'm seeing an increase. But I think what you're doing is great in terms of putting it out there to your potential clients or to the community to say, this is how important it is. Oftentimes I may hear, I don't have anything. But, you know, as I just spoke about, the little that you do have, you can protect it, or you have your person who
Right.
you just don't want anybody to make that application. You know, relationships are dynamic, they're different. You know, that one child who you could never see yourself living with, maybe the one that makes that application, and you know, you would never want that. So I would urge everyone to go and put it, you know, put it in place. The cost may seem a lot now, but what has to be sorted out and put together later is much more.
Yeah, that's what I see. Really, the cost is minimal. It feels like, you know, I even encourage people of my age to say to their parents, if they're struggling to get to the lawyer because they don't want to spend that, you know, $1,000, $2,000, I encourage you, pay for it, because it's going to save you so much trouble down the road. You know, to just offer to pay for it. And just quickly, how often, if they have, you know, if they've done a will when they were 50 and now they're 80 or 90, how often, like, should it be updated? It should.
Oh, that's been way too long. But really, all jokes aside, it doesn't mean that it's invalid, because, you know, so much time. As a rule, I will say to my clients, review your will, you know, every year, like you budget every year, like you set your goals, what you want done for the year. It doesn't mean that a change has to be done. But, you know, sometimes you put something away and then you read it again, you're like, huh, I don't even remember doing that. That's what I did. Or there's different circumstances that may happen that you really want to look to make changes, such as, you know, the family changes, there's a marriage or a divorce, or somebody dies in the family. The financial situation changes, either significantly you gain or you significantly lose. You want to really look at that. Did what I say before, does it really make sense with what I have now? Because remember, when the will was done, it was looking at what I had now, maybe looking at potential growth, but, you know, situations change. Health changes. You may have an executor that was diagnosed with a terminal condition. Well, do you really think that that's the best person to be the executor? So you want to look at those things. Or you have a beneficiary that's passed, and maybe you want those funds. Or, you know, you falling out in a relationship with somebody who you've designated something to, or you've even started a relationship with somebody who you really want to leave something to when you pass. So all of these things you really want to look at. You know, is it necessary for me to change it? When I send it, I say, you know, pick a day like April Fool's Day or your birthday.
I heard someone say on your birthday, these are the things you should look at. Is your will? I'm like, it's a little bit, you know.
Exactly.
But definitely something. And like me, myself, we did something when the kids were smaller, but now all my kids are grown. So I really need to update my will.
And you know, and that is something that happens as well as, you know, you have a minor child, you're definitely not making them your executor, but over time, if you feel that they're mature enough, they're, you know, over the age and they can really handle the situation, maybe then it makes sense that your children are it. But it doesn't mean that just because they're your children either, that they should be it. The dynamics may not be right for them. There may be someone else, you know, other things that you want to look at as well as the age of your executor. You know, does
you think they should be younger?
Yeah, they should be younger, but I mean, younger doesn't always mean healthier either. Again, it's just moving and who's there and how have things changed. Maybe somebody has, you know, moved halfway across the world. It doesn't make sense that they're your healthcare power of attorney. There's no restriction on that, but these are just the kind of things that you want to.
So just lastly, if someone is not in Ontario and you've got them as your executor or power of attorney, that's not a good idea. You should think about changing them.
That's correct. And it's not standard, right? You may have, let's say, a child that you want that child to be your power of attorney. it's just the logistics of it. You can always appoint more than one person as well. Because, you know, you may not want your cousin to be the one making that decision where you have a capable adult daughter. It's just that they're in another jurisdiction. Yes, they may have to come on a flight to get here.
Right.
Yeah, so it's really individual in terms of what makes sense.
Perfect. Okay, well, Michelle, I've taken so much of your time. I would like to thank you so much for answering my questions. I'm sure I'm going to get a lot more. We'll post this on YouTube and all the places, and hopefully we'll, you know, we'll get a lot of input and activity from everyone. Just to, I really need people to understand what it means to have their estate plan done. Right. So
it was a pleasure, Eileen. Thank you for having me. And I think that it's great what you're doing in terms of reaching out and education, because, you know, what they say, what you don't know can hurt you, right?
Right. And this is definitely all hurt the people you leave too, right?
Yes, that's right. And knowledge is key.
Yeah.
And it's best to get the proper knowledge and correct knowledge so that you can make an informed decision. And that's what's really important, is making informed decisions.
Yeah. Awesome. Okay. All right. If you